Hey, greetings. Welcome back once again to an all new episode of Categorical Imperatives. I am always am your host, Lockie and Liberal. Thank you so much for being here with me today. So, for those of you who may be more unfamiliar with the show, this is a podcast where we will be using legal and moral philosophy to discuss current events as it relates to various aspects of politics and culture. And for those of you who are more familiar with the show, I imagine there might be a number of questions that you are asking yourself right now, such as why does this video not appear to be about the Espionage Act of 1917? Or possibly why hasn't he put out a video in about a month now? I'm sure some of you are wondering what I wear while I record these videos. If I think about you at night when I'm falling asleep, did I get that thing that you sent me?
Did you get that thing? Did you get that thing? That I sent you. Did you?
No, I don't have time to answer all of those questions for you fine people today. I will say, first of all, to the person who keeps sending me boxes full of Rufinol and cassette tapes that seem to be filled with nothing but the sound of crying babies on them. That is entirely inappropriate. Please only send me one more of those and then cut it out. Uh, and as for the show, uh, for anyone who pays enough attention to remember, in my last episode, I told you that the next one was going to be about the Espionage Act of 1917 and Julian Assange. That episode is still coming. I'm actually doing that one. I'm really trying to get together with this other guy, another great YouTuber guy I really like, and collaborate with him on that video. I know he's a big supporter of Assange, like I am. I know he's been following the trial very closely, I'm sure. And I think he'll uh, be able to offer an interesting take on Julian Assange that will be definitely worth waiting for. So we have been in communication. It will be coming out at some point. We've just been having a lot of trouble trying to find the time to schedule to work that out, but it is on its way. And for the, I don't know, three or whatever of you who maybe actually noticed that I've been gone for about the last month, I haven't been posting videos. I had a really pretty severe computer crash a few weeks ago. So I lost, not only all my software and stuff, but I lost all of the things that I need for the show, like the logo that you see right now with the little character, the bear, and the wall. Yeah, so it's taken me a couple weeks to get everything back up to a point where I have my software installed and I can be putting out content for you good people. So I do apologize about that. I don't really do social media. I hate social media, so I really don't have much of a way to reach out to people if something like that happens. So I apologize, but I think we have a very good show for you here today. And this is actually something that I was working on right around the time that the computer crash happened. It's a little still now, but I think it'll still be a great episode. I'm going to be talking to you today about the 14th Amendment, which is a somewhat, I think, often esoteric part of constitutional law. And specifically, I want to discuss a particular aspect of the 14th Amendment that is known as incorporation doctrine, which is an even more esoteric piece of an already esoteric part of constitutional law. But it is a very, very important topic to understand if you are interested in the law, especially in American jurisprudence or constitutional law specifically. And this, the 14th Amendment, really is the one part of the Constitution, I would say, besides the original 7 articles that were drafted in 1787 and the Bill of Rights that was drafted and ratified in 1791. Aside from those two, which is really kind of the heart of the Constitution, uh, there is no part of the Constitution that is more relevant to how our government functions today than what we find in the 14th Amendment. So it is a very important topic to understand. And so what brought this on is I was watching an episode of a great podcast called Path to Liberty that's put on by the guys over at the 10th Amendment Center. And if you listen to my show at all, I'm sure you've heard me mention the 10th Amendment Center before. I bring them up a lot. I use them for sources on a lot of things. They're really great guys. I really love the work they do. However, on this particular episode, they were talking about the incorporation doctrine, and they have a view on it that while I respectfully disagree with them, I do still think that they are entirely wrong. Um, And because this is such an important topic and it's one that no one knows about, I thought maybe this would be a good chance to uh, use maybe the controversy, if you will, to sort of approach this topic. Uh, because I'll be honest with you, it can be a bit dry and difficult to understand at times. But again, this really is very important, and it is something that should really be better understood by everyone. So that's what we're going to be doing today. Before in the next episode, I'm going to be playing the clip of the show from the 10th Amendment Center that I'm talking about and show you exactly what they said. And we'll be going through it together, and I will sort of just kind of be uh, picking through what they say as I usually would do with any other video. But before that, uh, people need to have some understanding of what the 14th Amendment and the incorporation doctrine is first. And so I want to set that up with you guys here today. And then what I'm going to do at the end here, I think there's something very American about infatuation with conspiracy theories, and I love them. Not because I buy into them, but just because I find them fascinating in general. Just the way people come to believe odd things. And the 14th Amendment has some real wacky, crazy off the wall conspiracy theories about it. So, what I want to do today is I want to go through and I want to talk about the 14th Amendment. And then at the end, uh, I don't I feel like John Oliver doing this, which might not be a good thing because I don't think he is either informative or funny. But something that he likes to do is at the end of a very serious topic, he will have something very silly to kind of leave you off with. So that's kind of what I want to do today. I want to talk about the 14th Amendment and the incorporation doctrine with you good people. And then at the end, we're going to maybe just briefly discuss a couple of my favorite conspiracy theories surrounding the 14th Amendment, and we can hopefully have a good laugh at that together. So, why don't we just get right down to business? This is an outline of the conversation that we are going to be having today, talking about the history of the 14th Amendment. And to understand the history of the 14th Amendment, and the 13th as well. The 13th and 14th really go together. But we'll get into that. But so to understand the history of the 13th and 14th Amendment, we really have to trace their origins all the way back to the Constitutional Convention of 1787. And we will be going from there to talking about the seminal case of Dred Scott v. Sanford, and then on to the Reconstruction period following the Civil War. There's kind of a general outline of what we're going to be looking at today. And so we are going to start out talking about Article 4, Section 2 of the Constitution. This is what is known as the Privileges and Immunities Clause. And Article 4, Section 2 of the Constitution provides that the citizens of each state shall be entitled to all privileges and immunities in the several states. This clause prohibits states from discriminating against citizens from other states. And specifically, a state must guarantee certain fundamental rights, which, as I just said, are known as privileges and immunities. And it must protect these rights equally for not only its citizens, but citizens from other states as well. But what are these rights exactly? To understand those, really the most important thing to understand is an 1823 case known as Corfield versus Coriel. And this was a circuit court case from Pennsylvania, which has really come to be viewed as the most important judicial interpretation of Article 4. And Corfield was authored by a Justice Bushrod Washington, who was President Washington's nephew. And he wrote this opinion while he was riding circuit from the District of Columbia to the District of Pennsylvania. And Justice Washington explained that the clause protects privileges and immunities, which are fundamental, uh, which means that they belong of right to the citizens of all free governments. And he then listed several examples of privileges and immunities, including the protection by the government, the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. Now, this particular formulation of fundamental rights is actually something that was originally developed a bit earlier in May of 1776 by George Mason. And this is part of what he wrote, uh, essentially the Bill of Rights of Virginia, which is known as the Virginia Declaration of Rights. And in the Virginia Declaration of Rights, Mason refers to these liberties as inherent natural rights. And Mason's Declaration of Rights very directly inspired the Declaration of Independence, which was drafted by Thomas Jefferson just actually a few weeks later. And following that, Massachusetts, as well as several other states, incorporated Mason's definition of natural rights into their own state constitutions. And so in 1783, the Massachusetts Supreme Court invoked this language to hold that slavery was unconstitutional in that commonwealth. Now, Article 4 of the Constitution will play an important role in another slavery related situation. And this was from the 19th century at a time when free black sailors from the North would often be imprisoned while their ships were docked in southern ports. And Horace Mann and other anti slavery activists argued that the sailors were citizens of their home and that as a result, slave states were required to protect the same privileges and immunities for their own citizenry as well as for the black sailors from the northern states. And the states, however, countered and basically said that they could treat the black sailors, despite them being citizens from another state, they could treat them the very same way that they treated their own free blacks in the state under the discriminatory black codes. And the abolitionists uh, replied that Article 4 protected all out of state citizens from discrimination with respect to a set of fundamental rights of the sort that Justice Washington identified in Corfield. And Dred Scott v. Sanford, this is, of course, the 1857 case that held that people of African descent could not be citizens. And this argument relied in part on the scope of the rights of privileges and immunities in the Privileges and Immunities Clause from Article 4. And at the time, Chief Justice Roger Taney contended that if free blacks were citizens, then they would be granted all those privileges and immunities which are protected under Article 4. Taney went on to say that the southern states would never have wanted to extend to free blacks the full liberty of speech in public, as well as the right to keep and carry arms wherever they went. These rights are, of course, also protected by our First and Second Amendment, respectively. So, for Chief Justice Taney's argument to work, at the very least, we have to recognize that at least some of the rights that are protected by the Bill of Rights must have been thought to be privileges and immunities of U.S. citizens. In addition, Article 4 concerns itself with the rights of citizens of each state and citizens in the several states. It does not establish two classes of citizenship. But in the Dred Scott ruling, they did draw that distinction between state citizenship, which they said blacks could possess, and national citizenship, which they said they could never possess. So, really, one of the big things the 14th Amendment did was to eliminate that distinction between citizenship and between state citizenship and national citizenship. Now, of course, as many of you likely know, Dred Scott was a case that really helped precipitate the bloody Civil War that came not but a few years later, which, in fact, less than 4 years later to be exact. And it was this war that led to Dred Scott's repudiation. And in April 1865, as the Civil War was drawing to a formal conclusion, and Confederate General Robert E. Lee, at long last, did surrender to the Union General Ulysses S. Grant at Appomattox Courthouse, that the 13th Amendment was ratified 8 months later in December of 1865. And Section 1 of the 13th Amendment provides that, quote, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States. Section 1 did what President Lincoln's wartime Emancipation Proclamation could not. It eliminated slavery nationwide. However, the drafters of the 13th Amendment did not trust the states to voluntarily eradicate slavery. They also chose not to rely on Congress's implied powers to enforce the amendment. Now, if we go back to a case known as Prigg v. Pennsylvania, in that case, the Supreme Court offered an expansive reading of these implied powers that were that were written into the law, essentially to uphold the Fugitive Slave Act. So instead, Section 2 of the 13th Amendment granted that Congress uh, had an enumerated power to enforce this article that was Section 1 by all appropriate legislation. Next, we turn to the Civil Rights Act of 1866 and the Freedmen's Bureau Act. So, 3 months after the 13th Amendment was ratified, Congress relied on its new powers in Section 2 to enact the Civil Rights Act of 1866. The law provided that all persons born in the United States were citizens of the United States. Now, during the Civil War, President Lincoln's Attorney General, Edward Bates, concluded that free blacks born in the United States were citizens. So, therefore, they were eligible to serve in the Union Army. Now, his opinion directly conflicted with the ruling in Dred Scott, of course. And through the Civil Rights Act of 1866, Republicans in Congress tried to use statute to overrule Dred Scott. So now, people of African descent would be recognized as citizens of the United States. And the Civil Rights Act also guaranteed that all citizens of every race and color shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, as well as to inherit, purchase, lease, sell, hold, and convey real and personal property, and they would have the full and equal benefit of all laws and proceedings for the security of persons and property. Later that year, Congress enacted the Freedmen's Bureau Act, and this law established an administrative agency to advance the interests of the newly freed slaves. This act was also required the president to protect the rights of the freedmen that had been listed in the Civil Rights Act, along with an additional act that was mentioned in the Freedmen's Bureau Bill that protected the constitutional right of bearing arms. And this is a tie back to Dred Scott and repudiating Dred Scott directly. If you remember, Dred Scott, the two rights that he named were the full liberty of speech in public and the right to keep and carry arms wherever they went. So what the Civil Rights Act was is it was in a very literal sense a law that was meaning to essentially make Dred Scott repugnant to the Constitution. Now, in April of 1865, of course, President Abraham Lincoln was assassinated. He was replaced by Vice President Andrew Johnson, and the Tennessee Democrat came to oppose the Republicans' plan for Reconstruction. Once in office, Johnson vetoed the Civil Rights Act of 1866 and the Freedmen's Bureau Bill. He claimed that the laws were unconstitutional. Johnson argued that following the formal abolition of slavery, these measures now exceeded uh, that slavery had formally been abolished, and these measures went beyond Congress's Section 2 power to enforce the 13th Amendment. Now, the House of Representatives and the Senate both successfully overrode those vetoes on the bills, and they became law. Now, some members of Congress, including people such as Representative John Bingham of Ohio, who shared Johnson's constitutional concerns, uh, and he was also a member of the Republican Party, which also generally feared that the Southern Democrats would repeal the Civil Rights Act when their representatives returned to Congress. So, as a result, Bingham and others pushed for the adoption of a constitutional amendment to protect fundamental rights, such as those protected in the Civil Rights Act. And now we get to the 14th Amendment. So, the 14th Amendment was drafted to ensure that Congress had the power to enact the Civil Rights Act. Even if a future Congress repealed the act, the rights it protected were still be enshrined in the Constitution. Uh, and this was once the 14th Amendment was ratified, as it was in 1868. Now, breaking down the 14th Amendment and Section 1, particularly clause by clause, we start out with the Citizenship Clause. So, Section 1 of the 14th Amendment has four provisions, as you can see. Section 1 began by repudiating Dred Scott by saying, quote, all persons born or naturalized in the United States are and subject to the jurisdiction thereof. are citizens of the United States and of the state wherein they reside. So, Section 1 of the 14th Amendment, uh, as we can see here, tracks the Civil Rights Act of 1866. And it now ensured that those who were born in the United States, including the freedmen, were now citizens. Moreover, Section 1 eliminated the distinction that Chief Justice Roger Taney had drawn between state citizenship and national citizenship, and the Privileges and Immunities Clause. The second element of Section 1 of the 14th Amendment is the Privileges and Immunities Clause. It holds that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, this provision echoed the Privileges and Immunities Clause found right in Article 4, Section 2. However, unlike Article 4 and unlike the Civil Rights Act of 1866, the Privileges and Immunities Clause prohibited any abridgment of a citizen's privileges or immunities. The difference is that the text now barred two different types of deprivations of fundamental rights. Uh, and this was both laws that discriminated against some citizens as well as laws that discriminated against every citizen equally. So indeed, if we look right at the Privileges and Immunities Clause and we look at that phrase, no state shall, uh, that is identical to the prohibition that we find used in Article 1, Section 10 of the Constitution, which is what limits, that is the place where the state's legislative powers are specifically limited. So, for example, Article 1, Section 10, Clause 1 of the Constitution provides that, quote, no state shall enter into any treaty, alliance, or confederation. Additionally, uh, this phrase, no state shall make any law, resembles the First Amendment's command that Congress shall make no law respecting an establishment of religion. Now, one source of guidance to understanding the meaning of the privileges or immunities clauses can be found in statements of congressional proponents of the 14th Amendment. For example, Michigan Senator Jacob Howard was the amendment sponsor. There we go. All right. So, where are we at here? I apologize. Jacob Howard. There we go. So, Jacob Howard, who was the 14th Amendment sponsor, he gave an important floor speech during the debates for the 14th Amendment, where he remarked that the Privileges and Immunities Clause include whatever rights are protected by Article 4, and as he read Justice Washington's canonical formulation of fundamental privileges and immunities that we find from Corfield versus Coriel, that these are one type of privilege and immunity that is recognized by the Privileges and Immunities Clause. Moreover, this also includes the rights listed in the Civil Rights Act of 1866 generally, which these rights, if you remember, actually already more or less tracked the fundamental rights that were identified by Justice Washington in the Corfield case. And actually, in his notes, Senator Howard even refers to these Corfield privileges and immunities by calling them civil rights. And next, Senator Howard identified a second category of privileges or immunities, to which he said, the personal rights guaranteed and secured by the first 8 amendments of the Constitution. He then went on to list those provisions from the first 8 amendments on the floor. It basically every part of the Bill of Rights that protects individual rights. So next, we have the actual framer of Section 1 of the 14th Amendment, a gentleman named John Bingham. And uh, Bingham, when he introduced this legislation on the floor of the House, said Quote, the proposition pending before the House is simply a provision to arm the Congress with the power to enforce the Bill of Rights as it stands in the Constitution today, as well as many instances of state injustice and oppression having already occurred in state legislation of the Union, with flagrant violations of the guaranteed privileges of citizens of the United States, for which the national government furnished and could furnish by law no remedy whatsoever. So, contrary to the express letter of your Constitution, cruel and unusual punishments have indeed been inflicted under state laws within this Union upon citizens, not only for crimes committed, but for sacred duty done, for which and against which the United States government has provided no remedy and could provide none. So it was an opprobrium to the Republic that for fidelity to the United States, they could not, by national law, be protected against the degrading punishment inflicted upon slaves and felons by state laws. So the great want of the citizen and stranger were protection by natural laws from unconstitutional state enactments. And this is what is supplied by the first section of this particular amendment. So in Dred Scott, Chief Justice Tawney had also assumed that freedom of speech, as well as the right to keep and bear arms, were themselves privileges and immunities protected by Article 4. Likewise, we also saw in the Freedmen's Bureau Act that it protected fundamental rights such as the constitutional right of bearing arms. So, in this way, uh, the Privileges and Immunities Clause of the 14th Amendment overruled what had been a seminal Supreme Court case known as Barron v. Baltimore that occurred in 1833. This was 6 decades earlier. And in this ruling, Chief Justice John Marshall had concluded that the Bill of Rights only limited federal power. So now what was being proposed with the 14th Amendment was that the state's police power would also be limited by the fundamental rights of the first 8 amendments. Now, in addition to Corfield, the Civil Rights Act of 1866 serves as another uh, form of guidance in the meaning of privileges and immunities. So this federal statute did protect certain fundamental rights, as I kind of read through earlier, included the right to make and enforce contracts, the right to convey real and personal property. The 14th Amendment was designed to protect the rights specified in the Civil Rights Act from being repealed by a future Congress. This goal could only be accomplished if the fundamental rights listed in the Civil Rights Act were thought to be privileges and immunities of citizens of the United States. And like the Bill of Rights, the Civil Rights Act provided textual evidence that the rights it contained were so fundamental as to be considered privileges and immunities. All right. Moving on to Clause 3 of the 14th Amendment, the Due Process Clause. So, this third element of Section 1 of the 14th Amendment, the Due Process Clause, provides that no state shall deprive any person of life, liberty, or property without due process of law. Now, the Fifth Amendment already prohibited the federal government from depriving a person of life, liberty, or property without due process of law. So now, under the 14th Amendment, states were subject to the same restrictions. And finally, we have the Equal Protection Clause, Article 1, Section 4. This is that fourth and final element of Section 1 of the 14th Amendment, the Equal Protection Clause, which provides that a state cannot deny to any person within its jurisdictions the equal protection of the laws. So let's contrast the Equal Protection Clause with the Privileges and Immunities Clause. And there's a reason I'm doing this. According to the modern Supreme Court precedent, it's actually The Equal Protection Clause, the text of the 14th Amendment, excuse me, I'm sorry. If it is the Equal Protection Clause that protects the individual rights of citizens of a state. However, unlike that modern precedent, when we go back to the 14th Amendment, we take a look at the text from the originalist perspective, original meaning, which simply means how a reasonably intelligent member of the public would have construed a particular provision at the time that it was drafted. So if we take that original meaning approach or textualist approach to the Constitution, what we see here is a clear distinction between modern Supreme Court precedent that upholds individual rights on the states with the Equal Protection Clause versus the actual text itself of the 14th Amendment, which would suggest otherwise. And as I said earlier, just to kind of remind you guys, the Privileges and Immunities Clause was meant to prohibit two categories of legislation. The first one were laws that deprive everyone equally of a fundamental right, and the other was that laws that deprive some people of a fundamental right. Now, the Equal Protection Clause, by contrast, has a very different purpose. Its text does not impose limitations on the enactment of legislation. Rather, the Equal Protection Clause, uh, seems to require equal enforcement of the law. The states uh, had an affirmative duty at this point to enforce the rights of all its people equally. This meant for all people, white and black, male and female, and without regard to any other distinction. That is to say that the government had to protect the people both from governmental as well as private deprivation of fundamental rights, including the privileges and immunities of citizens of the United States. So, this right of protection mirrored the Civil Rights Act of 1866, which mandated that all citizens were entitled to the full and equal benefit of all laws and proceedings for the security of persons and property. So, Uh, what am I talking about when I mention the incorporation doctrine? We're really dealing largely with what we found in Section 2 of the 14th Amendment, those two different classes of individual liberties that they talked about. And so essentially, when the 14th Amendment had been sent to committee to be drafted in the first place, what had actually initially been recommended was something very limited. They just wanted a constitutional amendment that would do what the Civil Rights Act of 1866 and the Freedmen's Bureau Bill did, was to essentially repeal and repudiate the ruling from Dred Scott. So it does. This amendment does that. However, what also happened on top of that, as we just went through, was in the committee, and we'll get into this a bit more in the next episode, but essentially in the committee, we had John Bingham, who again was the framer of Section 1, who basically persuaded the members of the committee that if they were going to do this, that they should really try and go for something much stronger than just repudiating Dred Scott, and it was mostly, excuse me, mostly people like John Bingham who were pushing for inclusion of both the Article 4 privileges and immunities clause and incorporating that clause on the states, as well as incorporating the Bill of Rights onto the states. And this is the incorporation doctrine. Essentially, as I kind of sort of mentioned earlier, that the Bill of Rights was only originally meant to cover the federal government. At the time that it was drafted, absolutely no one thought that the Bill of Rights applied to the state governments. It was universally seen as applying to only the federal government. And again, this was something that had been upheld in the case of Barron v. Baltimore in 1833, where the court considered the idea of whether or not the Bill of Rights protected states and or federal or both. And in that ruling, they found that it was really only meant to protect the federal government. So, what the incorporation doctrine is essentially uh, besides just repudiating Dred Scott like the amendment was meant to do, uh, is this now took the pre-existing Bill of Rights that applied to the federal government and incorporated that Bill of Rights onto the states. And so it didn't create new rights, it just incorporated rights that were already recognized and protected by the federal government and put them on the states as well. And you there's a lot of controversy about whether this was a good thing or a bad thing, and we'll get into that next week. There's a lot of different opinions, and there's a lot of people who hold different opinions from mine, who I very respectfully disagree with. So it's really this is a very tough topic to understand on a deep uh, level. So all right, what we're going to do, I'm pretty much going to wrap it up here today. So look for in the next day or two, I will have another video posted. This will be the part 2 to this, and that'll be watching the clip from the 10th Amendment Center and their explanation of the incorporation doctrine, and then I will be uh, laying out what I believe to be the correct counter argument to their claim. And I think that'll be really interesting. This is because this is a controversy that is still very much alive today among people in constitutional law who follow this. This is still a hotly contested issue. So this is something that is worth understanding. And so tune in for that. Oh, and that's right. As I promised, if you want to hang around here for just a minute, just for shits and giggles, and I want to maybe just mention a couple of my more favorite conspiracy theories about what people think the incorporation doctrine actually is. I'll give you a hint. They don't understand that corporation means anything except a private for profit company. They think that is the only thing to which a term like incorporation can possibly apply because they barely apparently don't own a dictionary. So, and these conspiracy theories really let me bring this up. This is my scale of crazy. And the different conspiracy theories that you'll find really run the gamut along this whole scale. As you will see, the least insane uh, measurement is a tinfoil hat. Slightly more conspiratorial than a tinfoil hat is Alex Jones. Slightly more conspiratorial than that is Alex Jones in a tinfoil hat. And on the extreme end, we have Alex Jones on PCP. And so a couple of these are tinfoil hat conspiracies. A couple are Alex Jones on PCP. So let's just, yeah. So let's see. The first one is that the 14th Amendment made corporations people. This is the same faulty argument that people make about the Citizens United case as well. They don't understand that yeah, those arguments make absolutely no sense. But yeah, people make the same mistaken argument for the 14th Amendment Incorporation Doctrine as they make for Citizens United, that yeah, it made corporations people, which is not true, and that the idea of legal persons never existed before this, which is also not true. Another great conspiracy theory is that uh, it essentially was written to apply the Bill of Rights to corporations, and so therefore protect corporations from lawsuits by people. Another one is the belief, and this is gonna sound hyperbolic, but I promise you, this is what people really genuinely believe, uh, that the 14th Amendment makes literally every single American an actual literal slave. They believe that the federal government owns us as chattel slavery in the way that people were owned in the antebellum South. Another good one is they say, because a lot of people don't like the 14th Amendment. A popular one is that, well, it was never even ratified. There weren't enough votes for it to be ratified, which is ridiculous. But yeah, they do that with a lot of amendments they don't like. That's often done with the 16th Amendment as well. Uh, well, I wish that were true. I wish the 16th Amendment was an illegitimate amendment, that it had never been actually passed properly. This 16th Amendment is what gives the government the right to basically have an income tax, which did not exist before 1913. But that's a story for another day. Let's see, what else do we have? Uh, Oh yeah, we have the theory that the incorporation doctrine made our government a corporation, and that this is an added bit of crazy to that one. It made our government a corporation, uh, and the shares of stock in that corporation are our birth certificates. And again, I'm not being hyperbolic. I am being completely literal here. People think that our birth certificates, because of the 14th Amendment, are shares of stock in the people. I mean, for the people who own us. Let's see. Oh yeah, another great one is that the 14th Amendment created like a double secret, super evil second constitution that only legally binds the federal government to protect individual rights for people who are physically within the borders of Washington D.C. Washington, D.C. is basically a 10-mile by 10-mile kind of sort of swampy island out by Virginia, which is not part of any state specifically. Because it's the head of the government. And there are people that claim that what the 14th Amendment did was negate the old Constitution and incorporate a new constitution that only gave you individual liberties as long as you were physically within the geographic location of Washington, D.C. itself. It's not enough to be a citizen or a resident there. You can live there, and if you leave the boundaries of Washington, D.C. for that period that you are not there, you do not have fundamental rights until you come back. It's absolutely insane. Um, Oh, yeah, and then, I think maybe my favorite one, though it's maybe not the most, well, maybe it is the most absurd, and this is, the belief that there really is no 14th Amendment, and I've never really had anyone give me a good explanation of what they mean by that, uh, because I'm like, "Well, you mean it wasn't passed right or it's unconstitutional?" But no, they really think there's no such thing as the 14th Amendment. I've tried. It's just incredible. I mean, these people will actually say that they act as though there is no words anywhere on a piece of paper that says all the things that I just told you that the 14th Amendment is, which I think is just insane. And actually, I would give the highest rating on the scale of crazy. This gets honorable mention. This reaches the level of Alex Jones in a tinfoil hat on PCP. So, I think that's a good place as any to leave off for today. I hope you guys enjoyed the show. Something I always say is that if you haven't subscribed yet, please take a moment and subscribe so you can know when I have new videos come up. And then what I always ask people is that if you liked this video, if you found it helpful, you found it informative, I would just ask you to find one person you know who you think might appreciate the information in this video and pass it along to them, and just share it with one person who you think might appreciate this as well. And if you do that, I would greatly, greatly appreciate you. So, anyways, until next time, I have been Lockie and Liberal. This has been Categorical Imperatives, talking about the 14th Amendment and Delenda as Carthago.